Well, hello and welcome everyone to another session in the Solid Finances series. I'm glad you all could join us after our short break since our last sessions. A couple of housekeeping notes before we get started here today. First of all, I want to thank our sponsors, which for the whole series have been Montana State University Extension and North Dakota State University Extension. So we've collaborated to bring this program to you at no cost. And just a reminder, kind of the goal today is just to provide an unbiased resource. We're not selling you anything. We just want to help you build some skills and confidence so that you can make better decisions for your personal situation. If you've got questions today, please send them in the question and answer pod at the bottom of the screen. It is anonymous. No one else will know what you asked, and if we do get a question, we'll just say, we've had a question come in about this, and we'll read it that way. So feel free to be open and ask anything you can have a question about, and then we'll answer those periodically whenever we get to a break point, and if we've missed any, we'll catch them all at the end of the session. We're also going to have some polls today, so we'll have a variety of those, and this is for us to learn a little bit about you in terms of what you've done or what you know or what you're interested in. So please click on those, and the results will simply be a group result that'll show up that'll say like 50% of people voted this way or that way. So again, also anonymous how you particularly voted on those. Also, just a note, our website, msuextension.org/solid finances. This is where we keep our upcoming schedule. If you'd like to contact myself, all of my contact information is there. We also record all of our sessions, and we post our recordings on that website as well. And any handouts, we call them resources, that are related to the session are also posted with the recording that it goes to. So the session for today, the materials are out there, and the recording for today's session will probably get posted on about Friday of this week. It takes us a little bit of time to get that and get it edited and get it posted. So if you haven't bookmarked that site, it's a great resource for you. With that, we've got 2 sessions left after today. All 3 are going to be somewhat related to estate planning, and my colleague Marsha Goetting will be presenting all 3. So we do have today's session, and then on March 11th, we'll talk about financial and estate planning legal tools for the early stages of Alzheimer's, dementia, and other cognitive impairments. And then on March 25th, we'll wrap up the series this year with talking about families and legacies and some challenging decisions that need to be made there. And for those of you that originally made your calendar and marked everything, we did make a date change on that one, so you may not have that on your calendar. It was originally scheduled earlier, but we had to make a change there. So please update your calendar on those final 2 sessions for this year. With that, I'll introduce today's speaker, who's probably a familiar face to many of you in Montana, and for some of you, one of the co-founders of this series, Marsha Goetting here. So I'm going to turn it over to my colleague, and she's going to talk to us here a little bit about wildflower reflections, and then she's going to relate all of that into some estate planning things about whether or not someone should have a trust. So with that, Marsha, I'll turn it over to you.
Okay, Joel, thank you very much. And I'm excited to be here today to share my favorite kind of topics. And really, anything that has to do with estate planning is something that I'm very interested in. And one of the things that I've done in my programs recently is to use wildflowers as triggers. And I say that to sort of make the presentation a little bit more interesting, but also to give you an idea. Maybe you would remember some of these strategies and tools if you associated with a flower. So we'll try this and see how it works. And my very first flower here is one that I really enjoy sharing with audiences because I use that to share what it is I'm going to do. And in this particular case, it is a steer's head. So what that tells me is that I want to steer you towards an awareness of the benefits of having a written will. I also want to steer you towards an awareness of the differences between a living trust and a testamentary trust. So let's just find out a little bit about you guys and let me know, do you at this point in time have a written will? Well, it looks like that what we've got here is about 72% of you are saying you do, and 27% that say you don't. And what that tells me is you're better than some of my audiences, because nationally we know that 7 out of 10 individuals die without writing a will. It's just something that seems like it's difficult and challenging for people to get around to do. So here's a baneberry flower. And what I've got is a baneberry berries. Well, what this reminds me of is someone that, have you ever heard this phrase? So-and-so is the bane of my existence. And I saw one mother's will that actually went through probate. And she said, my only son David is not to receive a single penny from my estate for reasons well known to him and my family and friends, and for the further reason that since he's obtained a majority, he has been the bane of her existence. He has been disobedient, ungrateful, and a constant source of humiliation, anxiety, and sorrow. Well, now I'm not promoting that you would do something like this on your will, and as a matter of fact, an attorney would try to talk you out of that, because what it's the very last thing that you're doing and be remembered for, and this is really a tough one. But this mom wanted her son to know how she felt about it. So we're pretty much familiar with a will. It's a written document, and basically we are describing how we want our property to be distributed at death. And in Montana and other states that also have the Uniform Probate Code, there are generally 3 requirements. And one of those that you must be age 18 or older, and I think probably most of the people that are listening today meet that qualification. Then the other requirement under the UPC is that you must be of sound mind. And that is saying that you know the nature of the property that you have and know those to whom you would leave that property. And that's why attorneys will often recommend that you name your 3 children, even though you may not be leaving property to all of them. It's showing that you know the objects of your bounty. And I had one that I thought was a cute will. Here's your dad's will, says the attorney. Being of sound mind, I spent it all, says Dad. Well, I think my dad came pretty close to doing that in his situation, and I wish I could do the same. Now, do you think a will has to go through probate to be declared valid? Does a will have to go through probate to be declared valid? Aha, looks like what we've got here is that 81, almost 82% of you are saying no, and I'm here to tell you, sorry about that. Yes, a will does have to be validated through the probate process. In other words, we could write a will and we think that everything's hunky-dory, but until that will is submitted for probate and declared valid, then the things that are listed in there are not going to happen. So that's something that you need to keep in mind. Once you write your will, then it has to go through probate. Now, I say has to. Pretty soon I'll show you some examples where you may not have to do that. Now, I need to let you know, Montana is one of the states that allows holographic wills. We're one of 3 states that do that. And why compared to the rest of the nation? Because what happens when you're doing this yourself, you may not know some of the rules and regulations that go with it. But anyway, with a holographic will, you do not have to have witnesses. But the catch is everything must be in what they call the testator's handwriting. So I have an example of this. A man in the western part of our state wrote a will, and he wrote that will on motel stationery. And what we want to know, was the will declared valid when it was submitted for probate? Well, wow, it looks like I fooled you again, because guess what? The answer is no. You see, what happens is when a will is submitted for probate, the judge is going to take a look. And the judge is saying, I'm looking at this, and everything is not in the testator's handwriting. Well, if you think about it, what appears on motel stationery? Well, we might have a logo. We might have the name of the town. We might have the phone number, etc. So you see the whole thing there is here's a handwritten will. The intent is clear, but we have a judge that said, nope, we're kicking that one out because everything's in the testator's handwriting. So therefore, instead of distributing according to the will, what we're going to do is distribute it under Montana law. So you could have something like that happen in your community as well. Now keep in mind that when we do our wills, we can change them in the future. I run across so many people that did their will 10 years ago, 20 years ago, and look at your family situation. Things probably have changed during that period of time. Now, how do you change your will? Well, one way is you just revoke it. And that's what happens when you write a new will. Typically, one of the very first sentences that will go into that says, I hereby revoke all prior wills. And when you do that, you want to throw the old ones away. Don't hang on to them. The other thing is you could make an entirely new will. And in this day and age, with computers and software packages and attorneys saving the files, oh my goodness, it's so much easier than the old days when wills were typed. Now, I know a lot of you didn't even know or see or ever have the opportunity to type on a typewriter, but that's why you would use a codicil. I know one man had a 90-page will, and he wanted to change a paragraph. So all they did was change that particular paragraph and had it signed and witnessed just like you would do with a regular will. Now, I often get asked, do I have to leave at least $1 to each child? And no, that is not a requirement that you do so. In the old days, that was a way that you knew you were showing, I know I have 3 children. So what you can say is, I recognize I have 3 children, Maddie, Eric, and Melina. But perhaps what you have already done is helped Maddie and Melina with down payments on their homes. So the idea was that they would not inherit any property at your death. So that's the way that you take care of showing that. Here's a dad's will. I thought it was good. He says, to my son, I leave the pleasure of earning a living. For 25 years, he thought the pleasure was mine. He was mistaken. My audiences usually laugh at that one, and I can't hear you laughing, but I'm sure you are. Now, what about adopted children? Let's say that you've adopted children. Well, they have the same rights as your biological children do. And that same thing applies to grandparents. You know, once your children have adopted children, they are treated as your biological grandchildren. Now, let's take a look at these states that have the Uniform Probate Code. Will it allow you to disinherit your spouse? Well, we've kind of gone back and forth on that one. We've got 60% that says yes, by gum, and we've got 36% that say no. Well, in Montana and other states that have the Uniform Probate Code, no, you cannot totally disinherit your spouse. Now, I had a lady tell me at one of my meetings, she said, honey, I don't care what you said, I'm still going to disinherit, and you can fill in the blank there. So you see, the spouse has a right to what we call an elective share. And in many of our states with the Uniform Probate Code, that has changed. It originally started out that it's 1/3. So a man and a woman could be married one day, and that spouse could receive 1/3 of the estate. Well, now it's based on the amount of time that you've been married, and it varies according to this number of years. So what they have is an elective share, and then another weird word that's there is augmented. The augmented estate. And what they're doing is a 3-page description of that in the law. And basically it's saying we're going to add up everything he has. We're going to add up everything she has in her name. We're going to put those two together, and we're going to assure that at least the spouse, if they've been married, would receive a certain percentage of this estate. So if it was 7 to 8 years, it's 48% of the augmented estate. And here's Heine. I love this one. He says he left he made his wife the sole beneficiary on the condition that she remarry, because then there will be at least one man to regret my death. That's another one that you have my permission to laugh at. So now let's get down to some brass tacks. We've got John here. And what John has done is write a will, and in his will, he says, I leave $150,000 in value to my wife, Millie. But they are divorced. Well, goodness, who is going to get John's property? Is it going to be Millie, his former wife, or is it going to be Sarah, his present wife, John's children, or John's parents? What do you think?
And Marsha, we had a question come in, so maybe while folks are voting on this, we can address this. And we had about the augmented estate with the spouse there, and it was, does that exclude beneficiary designations, or is that just assets controlled via the estate?
It would include those. We had a case, for example, where a man left his property in joint tenancy. Well, it was in joint tenancy with right of survivorship, and he had his son's name on it. And in the process of doing so, he was disinheriting his spouse. So in that case, she could come forward. Of course, it had to be a court situation, and say, look, we've been married 40 years, therefore I am entitled to at least 50% of that ranch. So that's where it comes into play.
All right, thank you.
Okay, we've got a nice variance here. 60% of you are going to give it to Millie. We've got 20% that are going to give it to the present wife, and 20% to John's children. And the answer is John's children. Now, Millie doesn't inherit. Sarah, his present wife, does not inherit. And you might say, now, wait a minute, the will said Millie's name. But you see, for the states that have the Uniform Probate Code and this particular divorce situation, what we say is it revokes the bequest of property to a former spouse. So if there's anything out there like that, where we have life insurance, payable on death designations, TODs to that spouse, and you're divorced, that spouse isn't going to receive it. Now, of course, the will should have been changed after they got the divorce. A POD and a TOD should have been changed as well. So that's something to take a look at that may be specific to your state, but Montana passed it, and these life insurance companies that are located in Chicago and other places have to honor what Montana law says with those policies. Now, I ran across at one of my meetings a lady who had been separated for 20 years. And I got to give her the bad news that her separation decree is not a divorce. So even though she's separated for 20 years, if she passed away, her husband would inherit everything. And I think the fact that they've not been together for 20 years may indicate that she's not real fond of it. So my reflection for the Baneberries is you want to write a will to assure your wishes are honored and that you aren't the bane of somebody's existence. Okay, and also there's a good reason to contact an attorney to do this so that you wouldn't be writing a will that would be declared invalid. Now here I have two of my favorite flowers, and the one on the left is called an albino, and I was so excited when I found that in Yellowstone National Park because it's the first albino I've ever seen. So what this reminds me of is the albino family. See, I had to work the name in there somehow. And what I'm showing you is what this family looked like in the early 1990s. Husband and wife, they get married, they have children, the children get married, and then they bless these parents with grandchildren. So it's a really nice family. But then things started happening. In 1999, the son passed away as a result of an airplane crash in western Montana. The daughter passed away as a result of a car accident in eastern Montana. Then the next person to pass away in 2008 was the husband. So that meant that the whole estate went to the wife. And so we've got the wife and mother and grandmother all wrapped into one, and she passed away in 2010. But she did not write a will. So what I want to know is if we look at this grandchild and the will in this case, I'm going to say she wrote a will. Okay, sorry. She's written a will, and she says the property is going to pass by right of representation. So my poll question for you is, what fraction, if any, does grandchild D receive? This is the one where there are 3 children. Is it nothing? So you get to be a legislature. Is it nothing, 1/6, 1/8, or 1/9?
And Marsha, while folks are voting on that, we did have a question come in. How are spouses defined if there's not a formal marriage? How does the common law relationship get defined for these purposes?
Oh, I get that question at every meeting I do. And as a result of that, I wrote a Mont guide that it applies to Montana law or any other state with the Uniform Probate Code. Because you see what happens if we've got a common law marriage. And let me clarify this, it doesn't have anything to do with the number of years they've been married. It's how you've set yourself up to the public. So our Supreme Court has come up with 3 items that they say will help identify whether or not this is really a marriage. Now, the common law situation, let's look at a husband and wife, and they're living together. He has 3 kids, she doesn't have any. So he dies. What we've got is a court case, because I'll bet you money those 3 kids will say that was not a common law marriage, because then they will inherit all the property. Now, of course, she's going to come in and say, oh, but he gave me a ring. What he did is put a horse shoe that's in gold above the door, and my ring looks just like it. And we always signed our cards, Grandma and Grandpa and Mom and Dad. So what you've got is a court case, and the judge is going to decide between let's say, the surviving spouse, wife, and the husband by common law, his kids. So it's a court case. And so my encouragement would be, let's really think this through about living together. If we want to be married, we can do a marriage declaration. If we don't want to be married, then we make sure that we don't have joint checking accounts. We don't set ourselves up as being married. So that's my pontificate on that. Let's look at what you guys said. Well, 30% or 33% said 1/9, and you guys are the ones that got it right. The rest are kind of mistaken. And the reason is this right of representation is, it's hard for me to define. The easiest way is to look at this and say, how many kids did Mom and Dad have? Well, they had 3. So what that means is we've got right of representation divided by 3 in this case. So that means this one son that has the turquoise receives, his child receives 1/3. You see, it does not go to the spouse. It goes on down the tree, just like bloodlines of racehorses. It goes down. And because our daughter over on the right was deceased, that means these grandchildren only receive a ninth, a ninth, and a ninth. Now, explain to the two peak grandchildren, well, you get this because of the will, but the people are thinking, well, why didn't I receive something? Didn't Grandma love me? Okay, that's sad. So if we had our will and we said we're going to divide it equally to surviving children, so you see, the whole thing is, how do we word this in the will? Then how much would grandchild D receive in that case? Nothing, 1/6, 1/8, or 1/4. No, 1/8 or 1/9, sorry. Okay, we've got 60, down to 50. We've got 50% that said nothing, and the rest are all saying, or 16% are saying a 6th, an 8th, and a 9th. And in this case, the people that said nothing are correct, because it's equally to the surviving children, and the only surviving children is the son in this case. So how you word your will is so important. And if you go home and you take a look at your will and it says right of representation, then draw out your family tree and then start Xing out people that perhaps are already gone, or if you're wanting to do the what if situation. So my reflection from the albino fairy slippers is that those people with the uniform probate code need to understand what right of representation means when it's used in a will. Now here we have a heart-leafed arnica, and that makes me think of Joe Hart and Brooke Hart. And what they're doing is some heart-to-heart estate planning, and Joe has great heartfelt intentions. He has a $100,000 CD, and he has designated Brooke, his sweetheart, as his POD beneficiary. POD means payable on death designation. But oh my goodness, Joe's changed his mind. He's changed his heartfelt intention, and he writes this will. And in the will, he says, I bequest my $100,000 CD to my son, Eric Hart. So you know what I'm going to ask. Who is going to receive that $100,000 CD? Is it going to be Brooke, the POD beneficiary, or Eric? Because he was named in the will that was written after the POD was formed. So in other words, our will was most recently. Oh my, it looks like we're almost half and half. We've got 54% saying Brooke, and we've got the others that are saying Eric. So let's take a look at that one. Well, those of you that were saying the POD beneficiary are correct. Brooke is the one that is going to receive it because of the POD, payable on death designation. And what we've got to tell Joe is if he wants to change that, he needs to go to his friendly bank or credit union and fill out a new POD beneficiary designation form. It doesn't cost any money. He can do it as many times as he wants to. He can even have more than one beneficiary. So my reflection from the heart-leafed arnica is have a heart. Review your POD beneficiary designations on your checking account, savings accounts, and in Montana, we have Montana Medical Care Savings Accounts in which we can put PODs as well. Oh, I don't want to forget. Oh yeah, these are forget-me-nots. And in states that have the Uniform Probate Code, we also have a way to provide for treasured personal property items. And this is the way it works. All of us here have some personal items that we would like to leave to certain individuals. In some families, it's furniture, other families, it's collections, books, and in my case, it's wildflower photos. So our law allows for a separate listing of tangible personal property. And what it is a separate paragraph in the will in which you say, in my case, my Grandma Ray's opal ring is going to go to my niece Bethany. My Montana sapphire ring is going to go to Donna. And this separate listing is also available for people that have trusts. So I have an interesting situation. I've got Jack. He has a coin collection. He has a safe deposit box with John as a signer. And we've got a separate listing naming Susan. Now, who do you think is going to receive Jack's coin collection? Is it going to be John, because he's a joint tenant on the safe deposit box, or Susan? Well, it looks like here we've once again had a difference of opinion, and you're just split 50-50. And I've really got to smile at that one, because what I discovered is that we have a conflict in Montana law, and your uniform probate may be the same way. So I contacted attorneys, and guess what? It was 50-50. So my point there is being aware of that, and then really, do you want your safe deposit box to be in joint tenancy just so somebody can get in there when you have items that you've listed on your separate listing? Because we might have a court case over this. We've got, John saying, that coin collection is mine because it was in the box. And Susan is saying, no, sir, it's mine because it was in the separate listing. So that's something for you to think about. And one of the programs that we have available that was originally started by my good colleague in Minnesota, who gets Grandma's yellow pie plate. And so we've got that available for our participants. So don't forget, have a separate listing of your tangible personal property, and make sure that you coordinate that list with what you've got in your safe deposit box. So now that you know about this separate listing of tangible personal property, will you write one, or do you already have one? Well, it's great to see that we've got 70% there that are saying they're going to write one, and we have another almost 30% that say that they already have one. So let's take a look at trusts. Do you have some type of trust? Yes or no? Okay, we've got 85% that say they don't, and that is pretty typical. In an AARP study that was done, only 19% of age 50 to 64 have them, and you can see that amount goes up as we get older. So I'm going to use a sugar bowl to represent trust, because my mom used to have a sugar bowl at the top of the kitchen cabinet, and that's where she would stow away some money. And so that's how I think of a trust. It's a place to put assets. So let's take a look. A trust is really a legal entity that holds the title to property, and it's for the benefit or one or more people, and maybe it's an entity. And there's all kinds of trusts that are out there. And what you need is a trust for the situation that you have. I just don't support people that say everybody needs a trust. Nah, you don't. And a charitable remainder trust may work for individuals that are wanting to leave assets to charities and things like that. So first thing, decide on the name of your trust. This is James Simon and Lois Simon. They have named themselves as trustees. In other words, they're the ones that put the property in there, and they're going to manage that living trust. And typically that's what happens in a living trust. They want themselves to be still in control of their property. But it's a good idea to name a successor trustee. Who's going to take over if the trustees don't act, or let's say you get Alzheimer's or some other memory loss? You can even have a corporate trustee. But boy, howdy, I found that's really tough in Montana. We've got some that won't even look at you unless you have $1 million. And we've got others that say, we won't manage a ranch. We won't manage an apartment. We manage money. We don't want to have those hassles. Now, the beneficiaries are those people that you want to receive income from the assets that are in the trust or the assets themselves upon the death of the trustors or the trustees. And then every trust should have a trust agreement. That's the document that you use to tell people what you want to have happen. So again, you have to change titles on the assets that you want in the trust into the name of the trust. And what kinds of things can you put in there? Well, land, home, your checking account, certificates of deposit, securities. All these things can be in the trust if you want it to be. And the trust document only controls those assets that have been transferred. So in extension, we have a revocable living trust Mont Guide. That's our fancy term for a fact sheet. And that's on your resources list. So my reflection for the sugar bowl is, well, don't get bowled over with a trust until you learn more about them. And here, we've got a bitterroot, which happens to be the state flower of Montana. And I want to share some bitterness that can result from a lack of a trust, for example, in a remarriage situation. Instead of putting property in a trust when they got married, what the dad did was put this house in joint tenancy with his new wife. Now, the wife is a surviving joint tenant. She's going to receive it all because the son was not in the name of the trust. So if we want to avoid, if we go back there, we see, well, gee, he has disinherited his children. So what could he do? Well, first thing, we need to sever those joint tenancies that the husband and wife have. So they've both got to agree to that. And then each parent is going to place the property solely owned in that individual's name. And then each could write what I'm calling a testamentary trust in a will. In other words, they're going to keep that property in their name only, his or her, and then when the will goes into play, then it goes into the trust. So the will is the one that says, I want this house to go into a testamentary trust for the benefit of my surviving spouse. So in this case, we've got a husband that could go ahead and leave the farmland directly to his children, but he could leave the home in a trust for her. She could get to live into that home. And remember, that home, those kids grew up in, and that's why they want to receive it. So this way, she can't will it away to her kids. It's in the name of the trust. The husband puts in the testamentary trust money to pay for the property taxes and homeowners insurance and those kinds of things. So that could meet a goal. And then what happens then when the wife dies, that goes to the beneficiaries who are his children. And then at that point, they've got the land already, and then they will also receive the home. So my reflection from the Bitterroot is that trust can protect assets for children in a remarriage situation. Now here we've got a Richardson's geranium. And that reminds me of Granny Richardson. She has an estate planning goal that she wants to treat all 5 of her grandchildren equally. So what she did is she took her assets for the grandkids and she put some in mutual funds and some in CDs, and she put TODs and PODs on each one so that it avoids probate. Well, you can see right away we've got Joe up there who is going to receive over $10,000 if she dies, and we've got Tim who is going to receive $14,000. And she's saying, I don't want to keep changing the beneficiary designations to even these out. What could I do? And I said, well, Granny, I can't give you legal advice because I'm not an attorney. But I can educate you about testamentary trust. You could establish a testamentary trust, and in that trust, what she's going to do is designate the trust as the excuse me. The trust is going to be the beneficiary of all of her assets. So if we take a look at all the things that Granny has, what she's doing is saying it all folds into the trust at her death. So you see, we don't have to have probate because it goes into this trust. Securities, bank accounts, life insurance, all those things goes into the trust. And then the attorney will write in the will, in addition to directions about the testamentary trust, but a pour-over clause. And the pour-over clause says, hey, if I forgot anything, I want that to pour over into the testamentary trust. That's why you still need a will, even if you have a trust. And attorneys tell me you wouldn't believe how many assets people forget about because maybe it was something that was given to them or they bought years and years ago. Now, a benefit of this trust is you've got the money, everything in there, and what grandma is going to do is give income out to the grandkids. Well, the creditors have no right to reach that property that's in a trust, even if those kids owe money. And it could be, achieving Granny's goal here. She is going to be able to treat her grandchildren equally because she will hand it out, or according to the terms of the trust, a certain percentage to each one. So let's look at some other potential uses for a trust. What about minor children? Oh my goodness. If you're parents and you're leaving assets to children, you do not want them to access that at age 18. Now, come on. I'm sure you were very mature at 18. But if you look at the kids today, and I know I may be biased, but my goodness, should they inherit $2 million in life insurance money? I don't think so. And then you may have a financially incompetent heir. Maybe one of your grandchildren simply can't manage money. Or maybe you've got one that has addiction problems. I had a person at my meeting last night, and she's concerned about leaving property to her daughter who was addicted, who spent some time in prison. And so we explored the possibility of a testamentary trust for her, and she's got a lot of decisions to make before she talks to the attorney. And then this one comes to my mind. What about an incapacitated spouse? My mom had Alzheimer's. My grandfather had Alzheimer's. So I think, I worry about my chances. So you can have a testamentary trust and or even a living trust right now and say, if I'm diagnosed, in this case, a living trust by 2 doctors, then somebody takes over the management of my assets. As far as distributing, there's different ways you can do that. One is called discretionary and the other is mandatory. And one way it's discretionary is you have your trustee identified and you say, this is for the health, education, maintenance, and support. Okay. So Chris is coming to you. I'm making all of you participating today a trustee of my trust. And I said, I want you to use this for health, education, maintenance, and support. And Chris comes to you to take a trip during the summer to Europe because he believes it would be so educational. You're the trustee. Are you going to provide funds for a trip to Europe for Chris? Well, we can take a look at this one, and I guess I could say you are a little more conservative than some of my audiences because you're saying 90% of you know you're not going to provide those funds. And I have others that say, of course. So it's up to you. You're the life, you've got the trust, and you're the trustee. So if somebody asks you to be a trustee, you may want to know more information than health, education, maintenance, and support. Now, mandatory, or this could be discretionary too, but you can say when they graduate from college, they get X. When they get married, they get a certain amount. When they have their first child, they get a certain amount. Or you can leave all the funds when they reach a certain age, or at intervals. They get something at 25, 30, and 35. So I'm rather curious here. What age do you think is best for the distribution of trust funds? We've all heard of trust brats, I bet. What do you think is the best age? I had one lady come up to me and she said, "When do you think I get my trust?" And I said, "I don't know." And she said, "Age 65. So she's going to have a great retirement. But in the meantime, I think her grandparents wanted her to work. Well, if I look at this one, you guys are kind of scattered in your opinion. I would say that most of you are saying, well, certainly before age 50. But again, it's your decision because it's your money. Also, when you do this trust income or principal, your attorney is going to recommend that you use percentages instead of dollar amounts. Because, we're seeing a great example right now with the stock market doing what it's doing. You may not have the amount of money that you thought you would have, but whatever you have left that goes into the trust, you want to use those percentages. So a testamentary trust can be used to protect assets for minor children, those that have dementia or some sort of Alzheimer's disease, or maybe an incompetent heir. Well, my observation for the lady slipper is that it's about time for us to wrap this up, and I also want to give you an opportunity to ask additional questions, which Joel will share with us. But I hope I did steer you in the time that we had today to knowing what you can and can't do with a will. You cannot use a will when you've already designated by a beneficiary designation. It's just not going to work. And a will cannot undo a contract. And I hope I steered you to some of the advantages and maybe some disadvantages of a living or a testamentary trust. And if you're one of those individuals that doesn't have a memory like this elephant's head, yes, I hope you can see the elephant. I love this flower. There's the ears. There's the trunk. We've got in Montana 43 different fact sheets that have to do with estate planning. And that is our website. It's also on your resource list, and you can print those out that you're interested in. We even have one on gifting, which, is federal. We also have one on the federal estate tax, and I'm sure you're all relieved to know that you will not have to pay a federal estate tax if you have less than $15,800,000. That's why most of us are no longer worried about the federal estate tax. And don't forget, there are also fact sheets available in the estate planning area at your local extension office, whether you're located in Idaho, South Dakota, or North Dakota. All of those states have information about estate planning. All right. What other questions do you have of me, or things you want to make sure that I cover in our next two programs?
So, Marsha, I'm going to ask two questions that have come in, and then we'll do a quick evaluation, and then we'll come back to this screen so we can get some more questions. I'm going to read them both to you, and then we'll go to the other screen. So the first one is, can you suggest the best vehicle to protect an inheritance from a judgment? And then the second one was a clarification about how a testamentary trust provision protects assets from probate creditors.
Okay, we've got, the best item that would keep it from a judgment. I got to take a cop out here and say that's really a decision that an attorney would help you with. I can say, well, if we have an irrevocable trust, That's one that's very difficult to do anything with. But at the same time, irrevocable trusts are often used by those folks that have a lot of money and they're not going to miss that $50,000. Whereas if you take your asset and put it into an irrevocable trust to prevent creditors from getting at it, and it may not work. If that person is thinking about Medicaid, then I would encourage you to read our Medicaid and long-term care costs. Okay, Joel, will you do that testamentary question again, the second one?
It was how a testamentary trust can help protect assets from creditors during a probate process.
Okay, one of the rules that we should think about is even, when we go through probate, to leave enough there. Because even if you have a trust, we say, well, it doesn't have to go through probate, but we may have a circumstance where that was done under fraud type provisions, and therefore you could have that busted. That's not the word, but they have another word for it. And we want to pay our creditors. I mean, after all, we've had our debts and we want to pay for our own way. And we can have spouses that could end up being responsible depending if the debt was either just all his or just all hers. And even though you may have a POD, that POD is still subject to creditor claims. And I can say that in Montana. The other states, I'm not sure of.
All right, thank you very much. I have switched back to the main screen, so if you have additional questions, please send them in now. And while folks are having a chance to maybe type in any additional questions, just a reminder of our final two sessions, March 11th, financial and estate planning legal tools, specifically dealing there with things like Alzheimer's and dementia folks. And then March 25th, families and legacies and challenging decisions, and we will have Marsha back for both of those as well. So again, if you've got any final questions, now is your chance to get those sent in to us. All right, well, not seeing any additional questions, thank you all for joining us today, and thank you, Marsha, for presenting. And please mark your calendars and join us on March 11th for the next session in the Solid Finances series, and have a great day, everyone.
Thank you, and look forward to seeing you or hearing you.